Compensation with regard to employment terminations are taxed differently under various scenarios. A. Mutual rescission or termination (ICAL) of employment agreements. Mutual rescission or mutual termination agreement is an agreement that terminates the labor contract based on the mutual consent of the parties, ICAL. Mutual rescission or termination agreement isn't regulated under any specific law and in principle could be established in line with the freedom of contract principle, and therefore the establishment and validity of the mutual rescission agreement are subject to the provision of the Turkish Code of Obligation (TCO). Accordingly, when executing a mutual rescission or termination agreement, one of the parties shall explain to the other party its desire to terminate the labor contract, in other words, make an offer, and other party shall accept it. In Turkish law practice, mutual rescission or termination agreements are used for the termination of the employment contracts of employees who are eligible to the right of reinstatement within the scope of occupational safety regulation, and they are used to pay the compensatory right subject to such possible reinstatement claims in advance. B. Employment termination-based compensation in mutual rescission or termination agreements. Severance compensation. The issue whether severance compensation could be received if the labor contract is terminated through mutual rescission or terminal constitute a pivotal point in terms of mutual rescission agreements. Severance compensation or payment is regulated in the sole remaining article of the now abolished Labor Law No. 1475 that is still in force, Article 14. The conditions for receiving severance compensation are determined in the Article 14, and except for subparagraph 2 of Article 25 of the currently in force Labor Law No. 4857, that is rightful termination, any other form of termination by the employer seems to be sufficient in case the employee has been working for such employer for more than 1 year. Again, in terms of entitlements to severance compensation, there is no distinction between fixed-term and indefinite-term employment contracts. However, in the case of a fixed-term labor contract that expires within the specified period, the President of the Court of Appeals General Assembly, dated May 30, 2014, state that no severance compensation will be applicable. The court stated that the contract is terminated automatically in such cases. Since the compensation or payments to be received by the employee in cases of the termination of the labor contracts through mutual termination or rescission are not regulated in the law, the issue has been shaped by the President of the Court of Appeals, and the payment of severance compensation in cases of mutual termination or rescission agreement have become the practice in Turkey. Notification compensation. Although it can be claimed that the employee should not receive any notification compensation paid for immediate termination without proper notice in regular termination by either side as well, since the mutual rescission is in fact a joint termination statement by both parties immediately taking effect, notification compensation is also paid to the employees, considering that there is a sudden or immediate termination in practice, and the Court of Appeals precedent supports such argument. In its decision number 2016 and dated March 23, 2016, the 7th Civil Chamber of the Court of Appeals noted that the employer should pay severance and notification compensation to the employer in cases where the offer to execute a mutual rescission or termination agreement is made by the employee and the offer includes the demand of payment of his or her legal rights. Reinstatement or reemployment compensation. Other compensation are also included in the terminations made by way of mutual rescission or termination of employment agreements. As stated above, in practice, mutual rescission is generally used for risk reduction within the scope of paying reemployment or reinstatement compensation in advance, and in this context, payments are made to replace reemployment or reinstatement compensation that may be awarded by court later through claims of terminated employees. In order for the employee to file a reemployment lawsuit, the labor contract has to be terminated without a valid reason or without giving any reason, and the employee has to meet the criteria set forth in Article 18 of the Labor Law number 4857. The employer who terminates the indefinite term labor contract of an employee with at least 6 months seniority in workplaces employing 30 or more workers has to rely on a valid reason arising from the competence or behavior of the employee or the requirements of the business's workplace or job. Consequences of invalid termination are regulated under Article 21 of the Labor Law number 4857, which state that when the employee hasn't been given a valid reason or the reason shown is invalid and it is determined by the court or a special arbitrator that the termination is invalid, the employee has to start the employee within 1 month. If the employer doesn't start the employee within 1 month upon the employee's application, the employer is obliged to pay the employee a compensation amounting to at least 4 months and at most 8 months. Pursuant to Article 17 of the Labor Law, if the labor contract of the employees working with an indefinite term labor agreement, which are outside of the scope of Article 18, 19, 20, 21 of the Labor Law are terminated by abusing the right of termination, the employee is paid compensation in the amount of 3 months of the notification period. In practice, this compensation is called compensation for bad faith damages. Compensation for bad faith damages is subject to income tax as it is not counted in Article 25 of the Income Tax Law, which count the compensation that are not subject to income tax. In the event that the employee hasn't been allowed to return to work as a result of the labor contract terminated on the basis of invalid termination or without any reason, a compensation amounting to at least 4 and at most 8 most wages are envisaged. Whether this compensation is subject to taxation is regulated under Article 25 of the Income Tax Law number 193. According to Article 25.1 of the Income Tax Law, the compensation for not being allowed to return to work paid according to the Labor Law number 4857 are not subject to income tax. Compensation for not starting work mentioned in Article 25.1 of Income Tax Law are explained in Article 9 of the Income Tax General Communique, serial number 306. Article 9 of the Income Tax General Communique serial number 306 indicates that, according to Article 21 of Law number 4857, when it is determined by the court or a special arbitrator that the employer doesn't show a valid reason or the reason shown isn't valid, and it is decided that the termination is invalid if, given the application of the employee doesn't start work within 1 month, the compensation paid to the employee for at least 4 months and at most 8 months is within the scope of the exemption. Thank you.